and welcome from sunny, bright Phoenix on a nice December afternoon. We are here to talk about ethics, we are here to talk about rules, and we are here to talk about reality. Welcome to the Supreme Court broadcast of Ethics. Here's the rule. What's the reality? We are here to talk about both today. We have a very distinguished panel of guests here from around the state, from all different court levels, and we want to welcome those of you who are watching from all over the state at the various sites. We're glad to be here this afternoon. My name is John McDonald. I'm a partner at the firm of Jameson Gutierrez here in Phoenix. I'm also a former court employee, and I know very well how court employees are looking for ethics credit for COJET sometime around mid-December. I had to go through that every year, so if you are here for ethics credit for COJET, you are definitely in the right place. Before we get started on our various discussion topics, I wanted to talk to you a little bit about the format we're going to be using today. We have folks here from around the state, as I said, but really this is designed to be an interaction with you. We want to discuss these topics with you. We want you to have yourselves discuss these topics at your various sites. So there are folks there at your sites who are going to help facilitate the discussions, but mostly we want to hear from you. As the broadcast goes on, we are going to be putting up on the screen numbers that you can take your questions or your thoughts or the various scenarios that come up in your real life and fax those questions to us. The fax number that you're going to be seeing periodically is area code 602-542-3721. Again, the fax number is 602-542-3721. We also have an opportunity for you to call in and talk to us live on the air, and we encourage you to do that. The discussion will be much more lively and much more educational for everybody if we can talk with you. The 800 number to call, which we will flash up on the screen periodically, is 1-800-488-0782. Again, the number is 1-800-488-0782, and we will remind you of both of these numbers as we go along. The format we're going to go with here today is we're going to discuss each of these canons and each of these topics a little bit as we go through, and then we're going to kick it back to you and take about a 5-minute break each time to have you discuss these topics at your own sites. Come up with your own questions. Talk about what this means in a rural community. Talk about what it means in a more urban setting. Talk about what it means from the viewpoint of the judges or the folks who are actually in the courtroom, and also talk about it from the standpoint of maybe the probation officer or the others who are maybe out in the field or out dealing with the public. There's all types of viewpoints, there's all types of questions, and we want to hear from all of you. Before we get started here, I wanted to take the time to have our panel introduce themselves to you so you can have a feel for who's going to be discussing these topics today. I'm going to start on my right with Judge Dan Slayton and go from there.
Thanks, John. Good afternoon, folks. I'm Judge Dan Slayton from Coconino County Justice and Superior Courts in Flagstaff.
Good afternoon. My name is John Palander, and I'm a judge with Division 2 of the Court of Appeals in Tucson.
My name is Carrie Gerchik. I'm the Communications Director for the Clerk of the Superior Court in Maricopa County.
Hi, I'm Pete Kiefer, Criminal Court Administrator for Maricopa Superior Court.
Howdy. Laura Billings, Bullhead City Justice Court.
Good afternoon, Paul O'Connell, Court Administrator, Superior Court in Pinell County.
Good afternoon. My name is Tim Hardy. I'm with Juvenile Court in Yuma County, and I'm the Juvenile Court Director.
We're happy to have all of you here today, all of our panelists from around the state. As you can see, we have people from different walks of the court system. We have people who are here from different parts of the state, and we think we're going to have many different viewpoints represented here. So without further ado, let's move into the substance of why we're here. And that is, as we said before, I think it's evident in the title. Here's the rule. What's the reality? Obviously, there are words on paper. You probably have it here in front of you as you're sitting at your various sites. And those words are important, and they were constructed for a reason, and a lot of thought was put into them. But the fact is, each and every day, each of you in your various capacities, dealing with the public, dealing with defendants, dealing with probationers, whatever it might be, you have to take these rules and put them into practice. And there isn't a set guideline that will tell you what to do or how to react in every circumstance. And that's, I think, at the heart of what we're here to talk about today. How can you take these ethical rules and put them into practice and make sense of them in your daily existence. So I thought it might be interesting to start out by reading through a very brief passage of the preamble to the Judicial Code of Conduct for judicial employees. And what it reads is, a fair and independent court system is essential to the administration of justice. Proper conduct by judicial employees inspires public confidence and trust in the courts. There are certain principles that should govern the conduct of all judicial employees. What does that mean? It's pretty easy to dissect those words and come up with some relatively bland definitions, but what does it mean to you? What does it mean in your everyday life, and how are you going to put that into practice? With that in mind, let's go to the first canon that we're going to be discussing and that we're going to kick back to you in a few minutes to discuss in your groups and hopefully get questions and scenarios and thoughts back to us so we can kick it around here a bit. Canon number 1, judicial employees shall uphold the integrity and independence of the judiciary. Words like integrity, words like independence, those are words that can be interpreted by different people in different situations, obviously. There isn't one set rule. I thought to start out with maybe Judge John Palander, we thought we'd kick it over to you and get your thoughts on what does this mean to you in your daily life as a judge and maybe in the lives of your court employees.
Okay. Well, thank you, John. Again, Canon 1, which John just read, is pretty straightforward. It's a very short canon. I think it's the shortest of the 5 canons that we're looking at today. It's also somewhat general, but it's got some very fundamental principles that it addresses. The first, which is in Canon 1A, relates to independence, and it simply says, judicial employees shall maintain high standards of conduct so the independence of the judiciary is preserved. The second one, Canon 1B, relates to integrity, and it simply says, judicial employees shall maintain and observe the highest standards of integrity, honesty, and truthfulness in their professional and personal dealings. When we're looking at Canon 1, or any of the 4 other canons, obviously we want to look at the language first. What does the canon say? And then also, what does it mean? And the commentary, which follows most of the canons, including this one, hopefully sheds some light on the meaning and interpretation of the particular language used. But you'll notice a few things in looking at Canon 1 right now. First, in both Canon 1A dealing with independence and Canon 1B dealing with integrity, the word shall is used. And shall is a mandatory word. It's not should or perhaps, but rather it's shall. It means we almost comply with the standards set forth there. And also, if you look at Canon 1B dealing with integrity, it talks about not only our professional lives, but also our personal dealings, and that's an important concept. As John mentioned, independence and integrity are not defined. They're not defined in these canons, and they're not defined in the canons that relate to judicial ethical conduct. To me, however, independence connotes at least a judge deciding a case based on the facts and the law of the case before him or her, and not on such things as personal preference or bias or prejudice or favoritism. And that's an important concept for all of us to keep in mind. Integrity also is not defined, but in my way of thinking, at least, integrity refers to simply doing the right thing under the circumstances presented. If you look at the commentary of Canon 1, it says a couple things, but the last sentence I think is very important for us to keep in mind. It simply says, honesty and truthfulness are paramount. The last item in the materials that were handed out to you today is an article entitled Tough Questions in Tight Spots, Everyday Ethics for Local Officials. And a couple of quotes in that handout caught my eye, and they deal with this topic of honesty and truthfulness. Mark Twain once said, for example, none of us could live with a habitual truth teller, but thank goodness none of us has to. And that's something that Mark Twain apparently said, but I think it's kind of a sad commentary, at least on today's society, that honesty and truthfulness have been kind of shuffled and minimized. This article also quotes an African proverb which says, one falsehood spoils 1,000 truths. A pretty important truism there in a few words. And finally, advertising guru Joseph Sugarman said, each time you are honest and conduct yourself with honesty, a success force will drive you toward greater success. Each time you lie, even with a little white lie, there are strong forces pushing you toward failure. So these are important concepts in looking at not only Canon 1, but all the other canons as well. And finally, I would just point out that in looking at the canons, we should not leave our common sense out. I mean, common sense obviously comes into play in putting these canons into real-life practice. I sometimes think when I'm faced with an ethical issue, what would my mom or dad have said about this topic, or what would the pastor or priest or rabbi say about this situation? Also, I think it's sometimes good to think about if I did what I'm thinking of doing or don't do it, if I say something or don't say something, how would it look in the newspaper if it were in the front page of the paper the next morning? The bottom line to me is that every judge, but also every judicial employee, whatever we do or say, or don't do or don't say in a particular circumstance, may create perceptions and attitudes in others that reflect on the court as a whole and on the judicial system as an institution. So we all need to take care, it seems to me, to make our actions and our words, to conduct ourselves at all times, both on and off the job, in a manner that reflects positively, not negatively, on the court.
Thank you very much, Judge. One thing I know for sure after listening to you is Mark Twain never spent much time at the legislature. So as a lobbyist and somebody who spends a lot of time at the legislature, I want to thank the court for asking me here today so I don't have to be down the street for 2 hours. So I'm very appreciative of that. But I think your point was an excellent one, that common sense really is an underlying factor to all of these things. And trying to apply this in the daily life of a judge in where you're at, or probation officer down in Yuma County, or wherever it might be, really, if you think, what I'm doing, would I be comfortable if what I did or said or wrote was on the front page of the paper, is something that, as somebody who works in public affairs and deals with this is something that I talk to my clients a lot about. I know you want to write that letter, but you need to think about whether you want that letter or that statement on the front page of the local paper. And if you're okay with that, go ahead and write it. If you're not, then we may want to think of another way to do it. Mm-hmm. So I think your point is very well taken. Judge?
Thanks, John. One of the things that I just wanted to follow up on, and I think I speak for everyone here, is that as we're discussing these ethics and certain scenarios, we're going to be dealing not only with what happens in a court or what happens in any kind of judicial setting or in a probation setting, but also in the personal dealings that we have with the members of our community. And we all recognize that we're members of a community. And it's sometimes from Flagstaff, from Williams, Fredonia, Bullhead City, we see the very same people in our courtrooms that we see at a Safeway, at a church, at a community function, and they're watching us. And they're watching us very closely. And we don't know when they will be in our court system, and what they have seen us in the community acting as is going to influence how they view our court system when they come in to use it.
Right. Flagstaff, much smaller community, obviously, than Maricopa County in the Phoenix area, and you're going to have different scenarios there than you might have here. So these are the types of things we want you to think about as you're going into your group discussions. We want to send you back there now. This is going to be about a 5-minute break for us anyway. We'll be off camera, but now this is time for you to go into action and discuss the various scenarios that you can think of that might apply to this first canon, and how things may have come up in your daily job, or maybe you can think of a way that they might come up that might make an interesting topic of discussion. Check the fax number and the phone number that'll be on your screen. You can call us, you can fax us. We'd love to talk about your scenarios and the things you see in your community. We will see you in about 5 minutes. As the character from Saturday Night Live, Linda Richmond, might say, discuss. We'll see you in 5 minutes. Welcome back. Hope you had a chance to discuss these topics back at your local sites. Glad to have you back. And now we're going to take some time to listen to you and to hear what you had to say. I understand that we have a caller on hold. Caller, are you there?
Yes, I am.
Welcome. Thanks for calling.
Yeah, you discussed the topic of favoritism and how a judge should avoid that. I have aspirations of being a justice of the peace in rural Arizona, in northern Arizona. And I was born and raised there, and I practically know everyone in the town. What is the best way to avoid like the very appearance of favoritism? I mean, must I disclose prior to each proceeding exactly who I know and my relationship with him?
Well, you have aspirations to be a justice of the peace?
That's correct.
First of all, after I question your sanity, I think it's a great question. And thank you very much for calling. And why don't we kick it over to some folks who might want to tackle that topic. Maybe from the bench, you might, Judge Slayton, you want to tackle that from Northern Arizona?
As somebody, and I was talking earlier, as a fourth-generation native of Flagstaff, it's a situation that I come up against, knowing people there, growing up there. And yes, you have to be very careful and very cautious as to the depth of your relationship and the people that you know. And so if there are those folks that I either know personally or have had past dealings with, the requirement is to disclose that relationship. And that extends not only, I would say, to people who were born and raised in an area and may want to run for office there, but also I was a county attorney, and so I know attorneys that I have worked with. Some of the county attorneys have gone on to private practice. I had good, close relationships with them, and so those are the things that always rear their head up. Now, as far as judicial staff goes, there are a lot of judicial staff that work in our courts who have grown up there in the particular city where they may be working. And so they also need to be careful that simply because they know the folks, that there is not an appearance of favoritism based upon their friendship or the relationship with those folks.
And that's also something that certainly might be more acute in a smaller county, but here in Maricopa County, I mean, it's going to come up just as well. As big as the Maricopa County Superior Court system is, for example, it's still a fairly small community.
Yeah, it's a small community, and we interact with each other on a regular basis, and that's going to be a particular problem with in the criminal department. We work with the same deputy county attorneys and deputy public defenders, probation officers. There's always coming in, and of course it is extremely difficult to keep a balanced approach and a position of being apart when you're working with these people day in and day out. And of course you're going to, by default, establish a pretty good working relationship and friendships in many cases.
Right.
It's hard.
How about down in Pinal County? I mean, again, Pinal County is a county that really is evolving from what used to be relatively rural, and you've had a population explosion down there that just keeps growing. But I imagine that comes up a lot in your...
Yeah, that's correct. All of our judges are elected judges in Pinal County, and whenever they enter the political arena, it becomes difficult for them to, well, not difficult for them, but I'm certainly they're conscious of how they would separate being a judge as opposed to working with people, let's say, in the law firm that they had worked with before, and how they would work with them in a courtroom setting. I would just think that you would have to be upfront with them and honest and say, look, as a judicial official, I have to be independent of influences that would affect, my rulings. And I think once you're upfront with them, I think that could lessen the liability that you may have in the future.
Yes, Judge.
Even though we're looking primarily today at the Code of Conduct for Judicial Employees, it seems to me that the caller's question touched to some extent, at least, on the Code of Conduct for Judges, which of course is a separate code. And in that respect, I would refer the caller to Canon 3E and 3F of the Judicial Code of Conduct. And just very briefly, it basically sets up a reasonable person standard in terms of disqualification or recusal. It says a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to various instances that are then set forth in the rule. And the commentary says that, again, it's a reasonable person standard. If an outside, objective third party would have some reason to question the judge's impartiality based on the background, the association, the nature and extent of the friendship, and so forth, then the judge has to give serious consideration to disqualifying or at least announcing it on the record and allowing them to waive the potential conflict or problem.
Yeah, that's a very good point. And another thing to consider is the idea that a campaign and I've been involved in a lot of them, they are all encompassing, and they are, of course, are win or lose. There is no second place in a campaign for justice of the peace or whatever the office may be. So the idea of you're going to have your ethics tested in the campaign, and I would say to the caller to maybe think back to what Judge Palander said earlier, which is if your mom and dad would be ashamed of your conduct, that's probably a good reason to think you're going down the wrong path. And that sounds a little folksy, but I think it's true. Thank you very much for that call and for that topic. I understand we have another caller on the line. Caller, are you there?
Yes, I am.
Great. Hello, welcome.
Yes, we're calling from Pima County, and our question involves people who work with probationers and also people who work in the courtroom and who interact with victims and defendants and different people, and how they interact when they see these people in a social occasion or out in someplace like a grocery store. We do have a little more anonymity in a larger area, but those things still do happen. So our question is really, what tips do you have for us so that we can maintain our professionalism? And also, what duty do employees have to report things they might see other employees doing that they feel are inappropriate, and to whom do they report these things?
That's just an excellent question, and I really appreciate your group talking about this, and I appreciate you calling in. Thank you very much for the call. We'll take that question here. Tim Hardy from Yuma County. This is probably something that dealing with probation officers and the victims and the various people that comes up quite a bit in your line of work.
I think the issue that you would have to think about is when you're out in public and you're, whether you're in Pima County, Yuma County, or even Maricopa County, we all live in some type of community, you're going to have occasion to see these people. I think the most important thing is never to discuss anything that may be ongoing in the court system with them. Whether in my county our probation officers may see a probationer in the grocery store, and although sometimes they will use that as a contact, if they have something pending court, just don't discuss it. And that's probably the easiest thing to remember. In reference to the question about our duty to report, it is our duty to report as a judicial employee anything that is ongoing with an employee of the court. And the judicial canon mentions to report that to a supervisor or to a court administrator or even to the judge.
Yeah, very good point. Yes, Judge Palander.
Very quickly, just to follow up on Tim's comment, just recently the Judicial Ethics Advisory Committee issued an opinion on November 7th of this year, so it's a very timely question, a very pertinent and important question having to do with reporting of misconduct, whether it's a judge's misconduct or a judicial employee's misconduct. And I would encourage the caller, but really everyone, to look at opinion 03-03 of the Judicial Ethics Advisory Committee. The good news is that all the opinions, including a subject matter index for the Judicial Ethics Advisory Committee opinions, are now online and can be easily accessed and read from your office desk.
Yeah, very good point. I wanted to ask you, Laura, the second part of the caller's question dealt more with, okay, now this has happened and it's come to my attention, and what do I do now? How do I report this in a context where I still have to live with these people and work with them on a daily basis? And I'm sure this is something that you have to deal with periodically.
Basically, what I've done as a supervisor is just talk to that individual to see if they understand. Everybody has the canons in their somewhat manual, and kind of hope that it stops. But it's not just one manual, it's the reality of what they deal with, which we're going to discuss more later. But they have come to me and have advised me on a canon 2 that we're going to discuss that is a key issue with me. So we'll get to that later.
Okay, sounds good.
If
Yes,
I
Carrie?
may just comment, I think sometimes in terms of the second prong of the caller's question, it's important to emphasize that it's a lack of education on the employee's part. Frequently, it's not that he or she is trying to do anything wrong, but really that they don't know that. And so we're constantly, through efforts like today, trying to educate our staff. And it's it's a constant challenge. And in our office at least, we appreciate and value those employees who bring the complaints to us or point out that kind of when we need to educate on specific issues.
That's a good point. I think that's the role of a supervisor
Right.
to investigate those allegations of complaint. They may very well be unfounded. So, the role of the supervisor is very important in that regard.
I think I'd like to amplify that point in the respect that I think it's important to emphasize the duty and responsibility of the supervisor to adequately research and investigate these issues completely, because you don't know what you're doing and you could be affecting someone's reputation detrimentally if you react without having all the facts. So that's almost as important as the obligation of the employee to report.
Right. All very good points. I'm very happy that the callers took the time and that the groups took the time to come up with those questions. And as you can see, we want to talk with you and we want to make this interactive. So to the two callers, thank you very much for your work on that particular canon. And now perhaps it's time to move on to the second canon that we're going to deal with, and that is the Canon 2, which reads, judicial employees shall avoid impropriety and the appearance of impropriety in all their activities. And avoiding impropriety is one thing. Avoiding the appearance of impropriety is entirely a different thing. And clearly you have various interpretations of what is improper conduct or impropriety. And now you have to think about, not only do I want to not do the wrong thing, I don't want to even look like I'm doing the wrong thing. And this comes up, of course, in all arenas of government, whether it's state, county, local, legislative, executive branch, and certainly in the judicial branch as well. To start off with, I thought, Peter, I'd kick it to you and get your thoughts on how you see this evolving in everyday life.
This is a pretty powerful and broad canon that we're dealing with here. It's got a number of different aspects that we could probably spend all day exploring. First is the very basic of compliance with the law. You need to be complying with the law. Many of these aspects seem very straightforward, but if you think about some of the latest challenges that we have in our society, this is very difficult. What about individuals who might have strong religious or philosophical beliefs about some of the current issues that are coming up in our society today, protests on abortion clinics or areas like that, where they have to handle the paperwork for these cases and might be having to do things which they find repugnant because of their religious beliefs. Acceptance of gifts. This has been a long-standing thorn in many a court administrator's side, and we still are facing with this, the infamous box of chocolates that comes in every Christmas from a local attorney firm. It isn't directed to anyone in specific, but it is to show appreciation. Whether this is really appropriate. Abuse.
It comes from guys like me.
It comes from folks just like you.
Don't send them,
with the best of intentions.
Not that I've ever done
with
that.
the best of intentions, I might add. Abuse of one's position. This seems so obvious, but think about the possibility of soliciting for very good causes, excellent causes, and possibly putting too much pressure on your employees to solicit to a fine charitable cause. Certainly, this would be very questionable in terms of appropriateness. The employment of relatives and nepotism. Again, I think we're in the age where office romance is a reality, and it's not infrequent that you have coworkers who might fall in love and marry, and then you're faced with a problem of having individuals who one might be supervising the other, or they might be working in very close proximity. This is both an issue in some small towns, but also an issue in large urban areas. Use of public property. Obviously, one of the things that you always hear about is, geez, can I use the copy machine to photocopy Aunt Mildred's fruitcake recipe?
But not the fruitcake.
But not the fruitcake itself. Well, maybe you'd want to. Who knows? The other aspect, which certainly is coming into play more and more that you see from this aspect of public property usage, but also in terms of just the appropriateness of the kinds of things that we do, is how much access to the internet could you allow and permit your employees to be having? I mean, is it okay? Certainly, we know that accessing questionable websites is an abuse of public property and also inappropriate in terms of business. But what happens when you get an employee that you can see is accessing www.cats all day long? I mean, it's not really that offensive, but it certainly is an abuse of both the property but also the employee's time, the taxpayer's money. And finally, interaction with former employees. It is becoming more frequent now where you might get a individual who will have worked many years with the court system and then rotate off and find a job with a local vendor and will be coming back, maybe not even intentionally using their personal influence, but you understand it has to be there, and it's something that we need to, of course, always be sensitive to.
No, I think that one hits home for me very frequently because I used to work here at the Supreme Court, and I was very, very honored and happy to do so, and I still have many, many friends who work here at the court, and if I see them at the cafeteria and they're my friend, can I buy them an iced tea or a cup of coffee? I would do it just as a matter of course with my friends, but I really do have to think about it and say I don't want to do anything improper. And mostly what I don't want to do is put them in an uncomfortable position, but that's a sort of real life thing that could be magnified on a much larger scale for a much different situation.
Without question.
I understand we have a caller online who has a question here. Caller, can you hear me?
Yes, I can.
Hello, and thank you very much for calling.
You're very welcome. Thank you for letting me call in.
Where are you calling from?
I'm calling from the probation department.
Okay.
And my question was, how do we interact with the police officers?
Well, I think that's... Go ahead.
Go ahead.
Thank you very much for the call. It's a good question. It's a broad question. How do we interact with police officers from the probation department when these are people who clearly you deal with on a daily basis, and human nature being what it is, you're going to develop relationships there. And maybe what's the best way to take the human nature out of the equation as much as you can and try to keep it at arm's length and keep it appropriate? Tim, any thoughts on that and how you deal with that?
Well, I think especially in a small rural community, for instance in Yuma County, our probation officers are dealing with police officers on a daily basis. They deal with the police officers not only at work, but we're small enough to where maybe they have friendships with police officers. I think what needs to come out first is the cards need to be laid on the table, and it needs to be explained that no matter what the situation is, that it always needs to be a professional situation. We always remember that we need to represent the court, and if that is laid out to begin with, I think we're in pretty good shape. You may have relationships with law enforcement officers on a personal nature. We can never let the integrity of the court be questioned, and it just goes back to laying out everything to start with.
If I can just follow up on that, probation officers have certain roles that they have to perform, and police officers have certain roles that they have to perform. You have to understand what your role is in working with the police officers, and it comes down to professionalism. Once you understand what your role is, then the interactions would be cut and dry as to how you would function in the field.
As a general rule, would you all agree disclosure is just a key component when you've got a conflict that you think may be present? One thing to always fall back on is to tell somebody about it, and to maybe to have a record of it, or maybe just to have a conversation about it, to go ahead and lay that on the line. Judge Slade?
John, just before we went on, Paul and I made connection that we were probation officers with Maricopa County not that long ago, was it? It wasn't too long ago, really. But I think one of the things in kind of just talking about probation officers is a lot of times they are relying on police officers to be there for them. And you really can develop close relationships with them. But I think one of the most important things is that probation officers, as Paul was saying, understand what their role is. Their role is not to be an arm of the police department. It's not to be an arm of the public defender's office or the county attorney's office. They are employees of judges, and they are as every probation officer will tell you, they're the eyes and the ears of the court. When they get a case, they are to monitor that person with the intent of trying to aid in the rehabilitation, but also in the protection of the community. And it's a very strict line that I think probation officers really, when they understand that and they understand the boundaries, those relationships that they have with the police officers will be clear from the beginning. I had great relationships with the Glendale police officers that I had, 2 detectives. I had great relationships with them, but I had no problem of saying, I disagree with what you're recommending or what you're doing, and making sure they understood where I was coming from.
Judge Plaintiff.
Thank you. I think the caller's question is a very good one, but I think it tends to lap over a little bit into the next topic we're going to discuss, which is Canon 3, because Canon 3A talks about professionalism, and Canon 3B talks about impartiality. And I think Tim and Paul both mentioned those terms in discussing this particular question, but I think it's really critical to keep both those concepts in mind. None of us is a robot. I mean, we all live out there in the community. We have active lives aside from our jobs. And particularly with a probation officer, they're going to have very frequent contact with law enforcement authorities, police officers. But I think disclosure, as has been mentioned, is very critical. And I think, again, we need to take a step back in some of these situations and ask, what would an outside, independent, third-party observer, or particularly a defendant or defense counsel in the criminal context, think about this particular relationship, and would he or she want to know about it?
And the police department actually does have robots, but I don't think they're actually covered by the code. I want to thank the caller very much for that question. And I understand we have another caller on the line. Can you hear me, caller?
Yes, I can.
Great. Thank you very much. Where are you calling from?
From Maricopa County here.
Terrific.
Here in Phoenix.
Go ahead.
Yeah, I understand that there may be a fine. There's sort of a balancing act between being a judicial employee and also as an active member of a political party. Would it be improper, or would it have the appearance of impropriety if I were to participate in, say, a right to bear arms rally or a pro-death penalty rally as a judicial employee?
Well, that's an excellent question. I'm sure it's one that comes up all the time. I know in my time here at the court it came up quite frequently. Anybody want to tackle that, Peter? Does this come up in your line?
I think this is going to come up again with Canon 5, so we'll probably be revisiting this. In terms of my personal perspective on this, I think that public employees, court employees in particular, have every right to be able to express their political views at the appropriate time in the appropriate location. When it spills over into the court operations, that's when, of course, you have a bright line and you need to be sure that you're separating your role as a public employee from what your political beliefs are, no matter how strongly held.
Right.
Bumper stickers, shirts with...
Certainly not in the office itself. We would probably take a fairly dim view of that.
But those types of things do come up, and they can become big issues if they're not dealt with in a fair and appropriate way and dealt with fairly quickly. The issue with Justice Roy Moore in Alabama and the Supreme Court's ruling on his placement of the Ten Commandments in the courthouse is probably the latest, but I'm sure not the last example of how these things really do come into focus and can provoke an awful lot of passion from all sides of an issue, and it's best to get these issues and deal with them directly, but also deal with them fairly and in a way that treats everybody with some dignity and respect in the process. On this canon, I think we'd like to now take a break for a few minutes, have you discuss these issues and your thoughts, similar to what the callers have expressed, among yourselves back at your sites. We're going to break for about 5 minutes. Go ahead and spend some time talking about this, and we will see you back here, hopefully with some more call-ins or faxes, and we'll discuss those at that time. We'll see you in about 5 minutes. Discuss. Phoenix, thank you for being here. We want to, again, welcome all of you from around the state, and we're having a great discussion, and we're going to continue it now. Judge Palander, you had one thought here on canon number 2 before we leave that topic.
Very quickly, John. The last caller asked about the extent to which judicial employees could engage in political, particularly hot-button type issues in the community. And I just wanted to refer him to another ethics opinion. And I'm kind of familiar with ethics opinions, especially recently because I'm the chairman of the Judicial Ethics Advisory Committee. But again, these can be found online. And there's an opinion that I would commend to that caller's reading, and that is opinion 02-01, which was issued July 15th of 2002. And it addresses judicial employees' participation in civic life, including the types of things that the caller mentioned.
Great. Thank you very much. Now, I understand we have another caller on the line. I feel like Phil Donahue here. Is the caller there?
Yes, I am.
Welcome. Thank you for calling.
I'm calling from the Pima County Superior Court side. I work for Tucson City Court, and one of the issues that came up, we had further discussion about relationships with the public safety, law enforcement community at large. My particular situation is that I am a law enforcement wife. I've worked in public safety myself and now work in the court system. And we have many long-standing relationships with other officers, fire personnel, inspectors, judges, attorneys, this kind of thing, to where we exchange gifts because we go to church with them, we have attended each other's kids' weddings, that kind of thing. I guess the question is really, where do you draw the line as a judicial staff member on these relationships so as to avoid the appearance of impropriety, what's going to be considered impropriety and what is not, when you've got, like I said, very long-standing relationships with many people in the community?
It's a great question. Thank you very much for calling. Certainly this, whatever line there is, I think it's fair to say it's not a bright line, it's a very fuzzy line, and I think we've talked about that, what's inappropriate and what is incidental, and is there a way to distinguish between those two and try to figure it out as it's happening?
Mm-hmm.
I know.
That's a pretty tough one. I'm going to have to think about that for a bit. I mean, in one respect, particularly if you're in a smaller community, I think you could probably get too hung up on the implications of the appearance of impropriety. I think at some point you're just going to have to be able to settle in your own mind where that line would be for yourself and your own actions. Yes, I am good friends with law enforcement officers, fire department, public safety officers. I'm not going to give that up. But I think I would have to say, okay, there's at some point, and make it clear with other individuals in advance, you're not going to be asking me this. I'm not going to be telling you this. I don't want to be in a position where I have to compromise myself. I hope you respect me enough that you would never put me in a position where I would have to compromise myself. Now, is that going to satisfy the reasonable person who views that relationship from afar? I don't know. Particularly in a smaller community, it might be very difficult. But at some point, you have to live with yourself. You have to look yourself in a mirror and say, I'm okay. So I think that's sort of the bright line that I would have.
And one of the most difficult things to do in this setting or any other is to say no. Mm-hmm. And to be able to look your friend or your colleague in the eye and say, I just can't do that. It's a difficult thing to do, but it's one that needs to be kept in mind as you're going through your daily life. There's no easy answer to that question. But thank you very much for that question, and for all of you who called in with thoughts and questions on Canon 2. We appreciate it. Let's move on now to Canon number 3. And again, another very interesting area with no easy answers, but certainly a lot of room for discussion. Canon 3, judicial employees shall perform their duties impartially and diligently. Again, what is impartial? One of the things I certainly found in my days at the Supreme Court is when the Supreme Court or any judge rules, usually about half the people in the room are unhappy. So when courts rule in your favor, it's judicial wisdom. When they rule against you, it's judicial activism or impartiality, and it's just a fact of life. It's been with us since Marbury Madison 225 years ago, and it's going to be with us certainly in the courtroom but it's also with us in the other areas of the court system. And I thought I'd kick it over to you, Carrie, to start off this canon.
Sure. This is actually a rather lengthy canon. There are 8 parts to it, but I've broken them up into 3 main sections. And the first section requires judicial employees to be professional, impartial, and not be prejudicial in their actions. And as John was saying, there are many different definitions for all of those subparts. And for professional, judicial employees shall be patient, prompt, and courteous. That can mean different things to different people. Although, going back to what Judge Palander said earlier about passing it through, would our parents really be happy with the way we treated someone or the way we did something, I think is probably a pretty good way to measure or gauge that. In terms of being impartial, that is just absolutely crucial, and we saw that, the importance of that in the first canon. And, something that if judicial employees are not impartial with one third party, it makes that third party wonder about the credibility of the person. While we may go along with what the third party would like us to do, they're also questioning our credibility. So I think that's important. And not only does impartiality protect the court employee, it also protects the third party as well. And then the other part of that is prejudice. We cannot perform our duties with any sort of prejudicial thought in mind. And that is just as fundamental as the 2 prior ones. The next section focuses on information and records, access to information and records, as well as legal assistance. And those 2 subparts, D and E, are of particular and primary concern to us at the clerk's office, where we store over 1 million records in Maricopa County alone, and have hundreds of people asking for help each day on party on the legal assistance. And one of the challenges of the information and records, providing prompt access to the records that are open, is that we live in an environment where the technology is changing. So access to records means something different today than it did 10 or even 5 years ago. So with internet, access on the internet, that is an evolving and developing issue, and there are some proposed changes before the Supreme Court right now regarding Rule 123, which governs open access to records. And there are a lot of policy concerns that have really taken a long time, and rightfully so, to go through and try to figure out what's best, what's prudent, and what's safe. Now, in terms of legal assistance, that is a very tough one. The canon says that judicial employees may assist citizens in identifying available procedural options and understanding and complying with court procedures. The big challenge for us and for our employees at the filing counter is, what is the difference between legal information and legal advice? It's one thing to say, this is the form you need to fill out to get your divorce started. It's another to say, put your name here, or I suggest you file this as well. And it's very hard, because we have, as I said, hundreds of people coming to our counter each day. Frequently they can't afford attorneys, and fortunately the Superior Court does operate the Self-Service Center, which provides a number of forms and other information. And I know the Supreme Court has on their website a wealth of information on how to get things done. But frequently it's very complicated, and we'd like to help people, but it's hard to decide what that help actually is. The final third of what I'm calling the final third of this canon is regards to education, and that's crucial, because that helps us understand what our roles and responsibilities are. And also communicating with judges, that again is a common sense component. Judicial employees shall not communicate personal knowledge about the facts of a pending case to the judge assigned to a case. And the third, duty to report, judicial employees shall report to a supervisor any violation of the law or code. And that really just keeps everybody safe. And again, going back to Part F, really could just be an education issue.
Yeah, I think those are all good points. I think it's interesting to go back to the subject of human nature. Human nature would dictate you you work with these people, you live with them on a daily basis, and you want to retain whatever relationships you have. Hopefully they're good relationships. And that would probably make dealing with the third part of the canon, I'm going to report whatever violation I see. Well, pretty much everybody learns around kindergarten that when you start telling on your friends, life can get awfully difficult for you. So while I think the canons are there and they're meant to be interpreted exactly as they are written, real life says sometimes it gets handled a bit differently as we go through a day-to-day existence. I mean, would you agree with that, Paul, that real life and the canon sometimes don't quite match up?
Yes, what's the name of the show? Ethics is a rule, what's the reality? Absolutely, I would agree with that.
Yeah, well, and I think one of the aspects about that, which we're talking about, really is sort of wrapped up in the label of being a whistleblower of some sort, which can range from something very specific to something very broad. What is usually going through an individual's mind when they are thinking about whether they're going to have to report anything to a supervisor or even higher than a supervisor is, what if I don't have all the facts? And when do I decide that I have enough facts to move ahead? I've seen something that looks suspicious, looks sort of shady. Do I talk about it now and have it come back to me because I don't have all the facts? What is my obligation as another employee to actually do more investigation to make sure I have a correct interpretation of a situation before I move forward and potentially hurt someone's reputation? It's a very difficult subject, and a lot of people have been hurt when they've done this. A lot of people who have decided to step forward and do the courageous thing and become a whistleblower have hurt themselves. So I think this is one of the most important aspects of the canons, but also one of the trickiest.
Is it important to keep a record, Laura? I mean,
Yes.
is this something that you would advise people if you see something going on that you just have a feeling is not right? Is it important to write everything down, or is it maybe better to just keep this up in your head?
Well, it depends on what you're dealing with violations. Like we have public records, and there's some that have a different feeling on what they can have and what they can't have as far as the records. So it's not like you just hand them over and let them go sit in the lobby where you don't have some kind of control over it. We've had that with credit agencies that want to be able to come in and pull a file. You've got information that I don't feel is necessary, and if they want a copy, we have to charge them for the copy. They don't want a copy. They want to be able to see the file, and how do you black something out and still retain it? So difficult, especially in the public records.
Right. Go ahead, Peter.
No,
I'm sorry.
one aspect that we might want to think of as anybody was in this very difficult and challenging situation. Not only, I think, at least writing it down for your own purposes, a diary of some sort is very important. Also, to let it stay for a bit, even though it might be very crucial. Sometimes you need to give it a day or two, walk back to it, and in a colder light, a more dispassionate situation, say, okay, what do I really have here? What have I really seen? What have I really experienced? Oftentimes maybe even go to another trusted individual, ask them for confidentiality and say, this is what I know. What do you think? Because you weren't involved in it. Maybe your emotions aren't as wrapped up as mine before we move forward with, sometimes it's a very difficult situation if you had found maybe financial abuse or
Right.
or seen something that was completely inappropriate and possibly illegal.
And even more difficult if the person that you think might be doing this is somebody who
Is a
you
good
generally
friend,
trust and is a good
coworker,
friend and
yes.
somebody you have lunch with every day, makes it even more difficult.
Yeah.
Well, obviously a very good start to this topic. I think at this point we want to kick it back to you and have you talk about it some more. What is impartial? What is diligent? Talk about that in your groups. Are you going to tattle on your friends, or are you going to keep it to yourself? And maybe some real-life situations that you've run into. We'd love to have your calls. We'd love to have your faxes. We will see you back here in about 5 minutes. And welcome back to Phoenix, Arizona, to our broadcast dealing with ethics and rules in reality. Thank you very much for your participation. We're glad to have you from around the state. We're discussing Canon 3 at the moment, and I understand we have a caller on the line. Caller, are you there?
Yes, I am.
Hello, and thanks for calling.
You're welcome.
Where are you calling from?
Rural Arizona.
Okay, that's specific enough. We'll keep the rest of it to ourselves. Thank you very much for calling. What's your question?
Scenario is, husband is in law enforcement. The wife works as a court clerk. Is it appropriate for them to have lunch together with the officer in full uniform?
Wow. Then we have all kinds of Second Amendment issues on his weapon and all sorts of things. So, no, that's obviously not only a good question, but a very everyday, real-life scenario. And Laura, I'm sure it's something that, or at least the type of thing that you would deal with or have occasion to see.
Well, when that was happening, basically it's a small town, and they already knew that they were husband and wife in the community. But if they have lunch that day and the court clerk is a courtroom clerk and the officer has a civil traffic that afternoon, I don't think it would be a good idea if the defendant was at that same restaurant. So you have to be kind of careful, because that would definitely give the appearance of impropriety.
Well, and I think that's a very good point, and maybe a good thing to remember here for the caller or for whoever might run into this sort of situation is put yourself in the eyes of the defendant in this case and try to think, okay, if I was at another table at this restaurant or cafeteria and I was a defendant and I saw that, how would I feel? And maybe that's a good way to think about it.
Well, and I think maybe we ought to also turn this around just slightly in terms of, we're talking about what the appropriateness of the husband and wife having lunch, but what kind of preventions have they had to make sure that they deal with each other in a business setting as infrequently as possible? You might not even be able to say, well, okay, your husband and wife, you certainly have a right to have lunch, but if they are involved in a civil traffic matter, maybe they say, hey, I'm not going to be in the court when my husband is there, and I'm going to deal with the proceedings that he's involved in as infrequently as I possibly can, to just try to keep the separation as wide as possible.
Save it for dinner.
Yeah.
Yeah. All right? That might be a good rule. Save it for whatever discussion you're having. Maybe you could, that particular day, it might be okay to save it for dinner time. We also had a question come in over the fax, and the question basically dealt with, listen, we get things from the county or from the state or from our local community that comes perhaps in an email soliciting perhaps United Way donations or the state employee charitable campaign that would come through comes through the various court systems dealing with the state government. And yet court employees, as a general rule, I think, and it could be different in different jurisdictions, but as a general rule aren't allowed to solicit, whether it's through email or phone or personal contact, again, just as a general rule. But I think the question is an excellent one, and to whoever faxed it, thank you. It's a good point. How do you distinguish between what's allowed and what isn't allowed when the behavior is roughly the same? Carrie, you have any thoughts on that?
I do, John. Canon 4D specifically talks about solicitation, and it says judicial employees shall not use their positions or offices to solicit funds. But the commentary to it does say that a judicial office employee may provide information to other employees about a general fundraising campaign. So I think the key is in the fact that it's a general fundraising campaign and you're providing information rather than soliciting for specific funds.
Right.
So I think that that helps clarify it a little bit.
So maybe there's a difference between the actual generation of the campaign at that level as opposed to passing along information that comes from another source.
Correct.
Even there, though, I could certainly see where there'd be some conflicts that come up where people would say, well, what's the difference between this and that? And I don't think there's really a clear answer for it, but again, maybe getting back to some common sense guidelines as well.
Well, I think the clear answer is probably comes on a case-by-case basis, where that if a particular employee has a program or something that they would like to pass information on about, and allowing for differences between smaller and larger counties, I would recommend that employee take the information to his or her supervisor, who can pass it on to the appropriate person. There may be instances where not solicitation, but the sharing of information is appropriate.
One aspect that I think you'd have to at least keep in your mind as you're doing this is, could another employee be able to refuse to contribute and not feel any pressure? So I think I would use that at least as some sort of a line in my own decision-making process.
Sure, very good point. Now, I'm not on Canon 3. Do we have another caller on the line for Canon 3? We do not. Okay, I thought perhaps we had one caller waiting. Thank you very much for the fax question on Canon number 3. At this point, probably a good time to move on to the next Canon, number 4, which, again, no clear answers and lots of situations that come up on a daily basis and plenty of room for discussion. Canon 4, judicial employees shall so conduct their outside activities as to minimize conflicts with their employment responsibilities. Easy to read, more difficult to interpret. This is what courts do on a daily basis, is try to make sense of laws and rules as they are written. With that in mind, Judge Slayton, perhaps you had some thoughts to get us started here on Canon 4.
Well, let's look at paragraph A, general activities. Judicial employees shall conduct their outside activities so as to avoid a negative effect on the court or their ability to perform their duties. You know, as we've been talking this entire time, I think one of the things that I want to stress is that the whole purpose of what we're doing here this afternoon and discussing these canons and ethics is to help us do our jobs better. Where it's about professional ethics, not developing professional neuroses. And so, that's one thing I want to make sure that we're stressing. We understand that we all live in a community, and we're going to have outside activities. But we have to look at our activities in a way that is somewhat kind of like forecasting or foretelling the future, making sure that what we are engaged in is not going to reflect negatively. Under B, financial activities, this is kind of a long section right here, but I think really what is probably more relevant is to look at the commentary. And the commentary says, in order to avoid any employment that is in conflict with a judicial employee's official role within the judiciary, a judicial employee should not, for example, work for a police department, public defender, or prosecutor. Well, that seems pretty straightforward on its face. The fact is that judicial employees, whether you're a probation officer, whether you're a court clerk, whether you're working with civil traffic filings, or whether you're working with felony filings, you are going to have access to certain information that should not be accessible or put you in a position, I think, where you might be tempted to share that information with perhaps you're working for the public defender's office and somebody comes in with a search warrant on a client you know the public defender's office is representing. You don't want to put yourself in that position. I mean, that seems pretty straightforward enough. If you look, though, at under B, 1, 2, 3, 4, 5, and 6, what you're really looking at is, first of all, you can have a life outside of the court system, and you can engage in business activities outside of the court system. But obviously, you're not going to conduct business during your court employment or your whether it's for a probation officer, or a court clerk, or as a judge, obviously. You're not going to engage in something that's going to put you in conflict, where you have to make decisions that are going to compromise the integrity of the court system, compromise your integrity as a court employee. You don't want to put yourself into that position. You don't want to have one, obviously, that is going to, where you're going to be using court equipment or materials or supplies or telephone services. Yeah, these seem to be pretty straightforward on here. The last part of this, the commentary, though, I think is really appropriate. Judicial employees may become foster parents and may teach, lecture, or write on any subject. Now, these are just examples, keep in mind. So long as any payment is at the prevailing rate, you're not getting a special rate, either a discount rate on something, or you're getting paid more than what the prevailing rate is because of your position as a court employee. Any presentation or document clarifies that the judicial employee is not representing the judicial department. That's the disclaimer. I'm only speaking on behalf of myself, not as a representative of the court system, and any confidential documents and information are not disclosed. Under C, deals with a conflict of interest. Judicial employees shall manage personal and business matters so as to avoid situations that may lead to conflict or the appearance of conflict in the performance of their employment. Again, this is not saying that you cannot have outside employment. This is something that says if you do it, if you're going to go that way, then don't get into something that is going to put you in conflict. It's going to lead to problems. If it does, if you see something coming down the road, judicial employees shall, it's mandatory, inform the appropriate supervisor of any potential conflict of interest involving their duties. 2, a member of a judge's personal staff and the courtroom clerk shall inform the judge of any potential conflict of interest, involvement, or activity of the staff member or courtroom clerk in a case pending before the judge. And 3, judicial employees shall withdraw from participation in a court proceeding or court business in which they have a personal, business, or family interest that may actually or appear to influence the outcome of the court proceeding or business. Let me just digress here with a personal story. Everyone knows that I'm a fourth-generation native of Flagstaff. I've got lots of family members there. It was my first week as a prosecutor for the county attorney's office, and I'm sitting there in front of former Judge Cedillo, and we're doing a video arraignment, and up on the screen it pops a relative of mine, same last name, and they're in there on that video screen. Now, it's obviously very apparent when the defendant and the prosecutor have the same last name in the same community. That conflict is incredibly apparent. I mean, we all can agree with that. But let's put it a little bit different. Suppose a judicial employee has a business or is in, say, a lease, and then finds himself having to sue or being sued. That is something that can happen at any time, and it is something that you need to obviously inform your supervisor. You may have a family member who was arrested. You need to inform your supervisor. You need to make sure that steps are put in place so that the people who need to know are able to look at that situation and help you figure out the way to maintain your integrity and your professional ethics. A lot of times it's very easy to just simply take a case and transfer it to a sister court somewhere, and that's it. And you don't have to worry about that anymore. You've been protected and you've done what you should do. We've kind of gone over D, solicitation. Judicial employees shall not use their positions or offices to solicit funds, but judicial employees other than members of a judge's personal staff, courtroom clerks, or court managers may solicit funds in connection with outside activities. Let me give you the scenario that comes around, I think, in the spring. It's one of my favorite times, and that's Girl Scout cookies. And where you have court employees whose children are members of some youth soccer organization, something along those lines, and Girl Scout cookies. I think what was mentioned here is, which was mentioned previously, is that you want to make sure that your fellow employees do not feel coerced into having to sign up for 6 boxes of the Thin Mints.
Now, anybody who's ever sold those Girl Scout cookies knows that coercion is part of the deal.
I thought they sold themselves.
Mom and Dad won't want to buy them all.
That's right.
So I think that there are things that if you're going to do that, first of all, I would certainly check with your supervisor and make sure that everybody understands it. That's something that happens all the time. In our court system, a lot of times what you'll find is you go into the break room and it'll just be simply laying down on one of the tables back there where you can either sign up or not sign up, whatever you want to. It's not coming around to your office or to your space, and dangling it in front of your nose and asking you, to contribute.
Particularly from a person of authority in that particular office setting, that would be a very difficult thing to deal with. And I imagine that the relative popping up on the screen there might have made for a good conversation at your family Christmas party at some point down the road.
Yeah, and I will tell you that I also have a relative who is a police officer in Flagstaff, and so we run both sides of my family. The good, bad, and the bad and the ugly. And you can kind of figure it out as to where I fit. But I think it's a situation where you have to be sensitive. If you find yourself approaching that line where you're starting to feel uncomfortable, you're getting that, kind of getting that feeling in your stomach, talk to your supervisor. Let somebody in authority know what you're facing, what's happening. Don't face it alone. Go to them and talk it out. There's always solutions that can be made before you cross that line.
Okay, Judge, thank you very much. A great start to this topic. We, at this point, are going to take another break. We're going to give you time to discuss this, maybe take some of the things Judge Slayton has mentioned and discuss them amongst yourselves. Come back to us with a fax, with a phone call. Let us know your thoughts. We'll see you again in about 5 minutes. Welcome back. 5 minutes goes awfully quick when you're trying to think of the right things to say and answers to questions. But we're glad to have you back. Glad to have you from around the state. Welcome back to the broadcast. We did get a fax in dealing with Canon 4 and wanted to deal with the question. I think it's a very good one. I'll just read the fax. It says, as a court employee, do we have an obligation to tell if a family member has pending litigation? I'm going to assume from the fax that you mean pending litigation in that court. And for that, I think I would turn to members of the bench here and say, what are your thoughts on does it have an obligation?
I think that the judge would probably want to know about that. If it's a case that's in that particular courtroom, if it's just a pending case in some other judge's court in the courthouse, I don't think it's that necessary to tell, but I think the judge would want to know if it's a pending case in his or her courtroom.
All right. Judge Slayton?
John, let me just, and let me kind of bring out maybe what Judge Palander was talking about. In a superior court, where you are going up to a large window where you've got lots of people in and out, it may not be quite as critical or crucial, although my suggestion would be that, yes, you do tell your supervisor, because you don't want to have the other party seeing the court staff, the family member and court staff, and the other side buddy-buddy, yucking it up or joking with all the other members of the court staff. I think it's also, when you look at, say, a justice court setting where you have a lot more contact, you've got a lot of people in there, and in the rural areas where you have maybe an open window or an open counter where you just kind of lean on it and you're just talking to each other, it becomes even more critical and crucial that the family member who has that litigation, whose other family member has the litigation in their court, tell the supervisor. And what we've done is we've just made sure that that case does not go on that clerk's desk. They just don't deal with it. We find other ways around it to make sure that there is no appearance of impropriety. And again, it's that idea of looking at what may happen and setting up those protections in place that maintain the independence and the fairness and the objectivity of the judiciary and maintain the professional integrity of the judicial staff, so they don't have to worry about that. It's just not going to happen because the protections are in place. And I think it begins with talking to the supervisor and letting the supervisor know.
Yeah, disclosure. Disclosure's very key. Thank you very much for that fax. We have a caller on the line with a question and a follow-up on Canon 4. Caller, are you there?
Yes.
Hi.
Okay. My question is if it is a conflict of interest for a courtroom clerk to clerk for a visiting judge who has previously sentenced her husband.
Okay. Well, I would say that happens every day, but it probably doesn't. But it's a good question anyway, and it certainly deals with a much larger topic. Maybe from the standpoint of clerks, Carrie, I could kick that one to you. And
sure.
What do you think?
Sure. I think, I'm sure there's a particular canon that speaks to that issue, but I think it really just goes to common sense. And I would urge that courtroom clerk to notify the visiting judge that she clearly has a conflict. And we at the clerk's office have a pool of clerks, floater clerks we call them, that go from courtroom to courtroom as necessary. And it's generally not a problem to find someone to sit in for that clerk. So I think absolutely that letting the supervisor know would be the best bet.
Would that be a bigger problem, more acute in a place like Bullhead City, where you don't have a pool of people to go around?
Basically, I do, because it cross-train my staff.
Okay.
So if there is, like the judge mentioned, video coming up and it's a relative, or if you're doing an education class and one of the people that come in happen to be the father of one of the children that are there for the education class of the courtroom. So any scenario, basically, all you have to do is talk about it. And usually it becomes clear because you get somebody else to look back.
It's better to know before than after.
Right.
Right, but I mean, you talk about it.
Yes,
but
I
there
agree.
has been times where, like, they pop up on the video, or they come in. A lot of people have nicknames, and they go by nicknames. I've been on the bench and wasn't even thinking about the nickname. Looked at the calendar, and a person comes in front of me, and I'm going, "Oh, I can't do this."
Mm-hmm.
So,
but to your point,
happens.
You can't find a solution if you don't know there's a problem.
Mm-hmm. Yeah, right.
Right. I would think that would be an extremely uncomfortable position for you to be in, and I think if you would talk to your supervisor, then other arrangements could be made for you.
Great.
Good. Thank
Change
you.
clerks.
And thank you very much for the call. We have another caller on the line. Are you there?
Actually, I'm the same caller. I just want to add to that question. What if the supervisor is the person who delegated that clerk to be clerking for the visiting judge, and the judge never said anything about it? Shouldn't the judge take it upon himself to say, hey, I'm not going to let you clerk for me?
The clerk should.
Yeah, I guess.
But the supervisor is delegating the clerk to clerk for that visiting judge.
Was the supervisor aware of the conflict?
Oh, yeah.
Then I would recommend that you go to the supervisor's supervisor.
Correct.
Yeah, but I'm sure there's a real world, and thank you very much for the call. I think it's a very good question. Thank you for calling in. I'm sure in the real world, going up the ladder there is going to be perhaps a very difficult choice to make, but at some point you may run out of options.
Well, and quite honestly, the judge is not the one who determines who the courtroom clerk is. So in the final analysis, it's going to be someone within the clerk's office. And speaking for the clerk's office in Maricopa County, we would absolutely want to know if there was that type of conflict, and would encourage you to, or whomever, to report that accordingly, and to keep reporting it.
We had a fax come in that I think is going to be discussed somewhere down the line. The fax, and we very much appreciate it. I love the first question. What do we do when candy is left at the counter around Christmas and no one is around? As a chocoholic, I can tell you what I would do, but I don't think that was the point of the question. It goes on to say, or if someone brings a clerk a plant to thank the clerk for being courteous, calendars that might be left at the front desk for with no particular name on it. What do you do then? And I know Laura, you this is something that you've come across, and I'm sure everybody has to some degree, but there's no easy answer to that.
Well, you feel like a Scrooge is what you feel like, because you have to tell them no. I just get disappointed sometimes with the attorneys that also have ethics, that they put us in that position by bringing us the candy in the first place, knowing that we can't accept it. I did have a plant brought in for this scenario. It might be our group that's sending it. And we had to take it to the hospital or take it to one of the retirement homes, because in our setting we have a small lobby, but there's always a lot of people in there, and they see this transaction. And in order to keep the integrity, we have to give it back and have those people hear us give it back.
Peter?
True story. My first real job in the Multnomah District Court, Portland, Oregon, court of limited jurisdiction. When I had joined the court, there was a long-standing tradition of accepting gifts from local attorney firms. The new court administrator, who I have a lot of respect for, put an end to it. When the candies came in, she boxed them up and sent them back with a very nice note to the attorney firm saying thank you, but it is unethical. Cited the canon for the Oregon revised statutes where we were unable to accept these sorts of gifts. She was extremely unpopular.
Yes.
over, I'd say it was about a 3-year period. It stopped, and I think the court was better for it. Was it easy for her? Absolutely not. Was it the right thing to do? Yes.
And a difficult message to deliver. These are the things that come up, and when they do, with all due respect to the courts, those are the days when I'm very happy to be in the private sector, because that candy don't last long around my office. So, again, great faxes, great questions. Thank you so much. We're going to move on to Canon 5 now, our last topic. And Canon 5, judicial employees shall refrain from inappropriate political activities. I could make a case that inappropriate political is redundant, but I won't go there. As somebody who's at the legislature quite often, I have a great deal of respect for the political process. It's the foundation of our government, it's the foundation of our way of making decisions, and politics has become such a dirty word in the American lexicon. And really, what it is it's the process of discussion. It's the process of debate in our government, and it's the process that, frankly, for the most part, works pretty well. But clearly, there are elements of politics that need to be removed, especially from the judicial branch. And I thought, Peter, we could turn to you to maybe lead off the discussion, and then we'll let you all talk about it amongst yourselves again.
Yeah. Canon 5, in my opinion, is probably one of the most specifically focused canons, which states that judicial employees shall refrain from inappropriate political activities. When the canon is laid out, it probably doesn't cover all of the potential areas, but certainly a broad enough spectrum that folks that I think have an adequate set of guidelines from which to work. Certainly the very first tenet of the canon is general activity, political activity, is appropriate, is acceptable, as long as you, as a court employee, are able to separate yourself from the court. If you happen to be advocating for or against a school bond measure, you can do that. That's fine, as long as it's clear that the court is in no way connected, one way or the other, with the kind of activity that you're engaged in. When we're looking at elected office, it separates out the difference between partisan and nonpartisan positions. It allows court staff to run for elected office. If it's a partisan office, it states under C1 that you are to take a leave of absence, an unpaid leave of absence. And again, separate yourself from the court as the independent branch of government. Nonpartisan offices, it's a little bit more lenient. I believe it states that you're to get approval from the presiding judge, potentially even the Chief Justice, it's appropriate, and to ensure, again, that if you're running for a nonpartisan position, I suppose with the school board, that again, you are separating yourself from the court. Other bright lines to be looking at, tenants, no political pressure. You definitely do not want to be imposing political pressure upon your staff in any way. If you are a court employee who is working for a judge, you can certainly volunteer to assist in a judge's campaign for re-election, though again, it has to be clear that you are doing this entirely voluntarily and that there is no political pressure being imposed upon you for the judge's sake and for your other co-workers. And of course, lastly, no political discrimination. We want to ensure that the judicial branch fair, impartial, and separate from inappropriate political activity.
And sometimes hard to decide what's appropriate and inappropriate, but again, going back to some common sense guidelines in addition to the written guidelines. Thank you very much, Peter. A good start to this topic. We're going to give you one last chance here to discuss this on your own. Maybe you can talk about some things that have come up, particularly in the rural communities where so many of the judicial officers are elected officials as well. Sometimes we forget that here in the state of Maricopa. So take time to discuss this. We'll see you back here in about 5 minutes. And welcome back. We are coming down the stretch here from Phoenix on our broadcast of Ethics. Here's the Rule. what's the reality? I can tell you the off-camera discussion is every bit as entertaining as the on-camera discussion. We may have broken a couple of ethical rules in the off-camera discussion, but we won't talk about that. Judge Palander, you had some thoughts as we come back from the break here.
Well, not so much thoughts, just some points I wanted to bring up. 3 points in particular. One is that the Judicial Ethics Advisory Committee has put out 2 opinions touching on the subject of appropriate and inappropriate political activity of judicial employees. And I would bring those to your attention. One we've already talked about, that's opinion 02-01, issued July 15th of 2002, involving judicial employees' participation in civic life. The second one is opinion 03-05, issued October 30, 2003, involving judges, family members, and judicial employees' participation in political activities. So I would commend those 2 opinions to your reading. The second point is an important point relating to not only Canon 5 that we've been discussing here, but also Canon 4D, which I think relates to solicitation of funds that we talked about previously. And that is the distinction that these canons draw between some judicial employees, on the one hand, versus another category of judicial employees that fall within one of these 3 definitions: court managers, courtroom clerks, or personal staff. Now, all 3 of those are terms of art that are defined in the definition section of the code that we're looking at today. But I would encourage you to keep those distinctions in mind, because if you're a court manager, courtroom clerk, or personal staff, then different rules apply to you under Canon 5 as well as Canon 4D. And the third point, which is probably an obvious point, but that is we've learned this afternoon there are many gray areas, there are many important issues that come up under the canons, but some of these questions that you've sent in don't have easy or clear answers. And that's why the Judicial Ethics Advisory Committee exists, not only for judges but also for judicial employees. And I would encourage any of you who run into an issue or problem that is not self-evident under the code, that's not clear, doesn't have a clear-cut answer to it, that you do not hesitate to contact the Judicial Ethics Advisory Committee, because that's the purpose for why we exist.
Great, Judge. Thank you. Tim Hardy from Yuma County. Off the air, we talked about some situations that might come up, or maybe have come up down in Yuma County, and how you dealt with them down there.
They have. One of the situations that came up probably about 3 years ago, an issue where not only the juvenile court but also the Superior Court needed new building. And we were instructed that we could educate the public, but in no way could we either favor or disfavor the project while we were employees during working hours. So that was quite interesting. One of the things I would just like to bring up is ethics may be a dry subject, but it is a subject that comes up in our life every day. And the authors of the judicial canons realize that we're all human. There are many different opinions, and nothing is in black and white. This is a very, very gray area. So just remember, out there when we're doing our job, if it makes you feel uncomfortable in any way, then you need to take it a step further. And like the judges have mentioned, if it makes you feel uncomfortable, how will you feel about telling your family? How would you feel about if it's on the front page? What happens is they don't remember our names, but they do remember that we're judicial employees.
And Paul, you had some thoughts about things that have come up in Pinal County.
Well, there are no political priorities in Pinal County. But other counties, we could probably talk about that. I think when you read the commentary regarding this particular canon, there's a word that just jumps out at me, and that's neutrality. The court has been described as the quiet branch of government, and there's a reason for that. They have to be impartial, neutral, to conduct business, and that leads to public trust. So using the court or the courthouse for political activities, or using your staff for personal gain, is definitely inappropriate. Courts have to remain neutral. There can't be any fundraisers within the courthouse. There can't be any luncheons to introduce political candidates. There can't be any petitions on one's desk as you pass by and encourage you to sign them. There can't be, in our particular courthouse, for example, we had a political party that used the courthouse in the evening for meetings. That has stopped. and because it favors one political party over the other. So neutrality is the marching orders for the court when it comes to political activities.
That actually brings up a good point. In some of the smaller communities, like Bullhead City, for example, there may be facilities that are common places for the public to gather and to do certain things. Does that come up as an issue where they might want to use it for an activity that on its face seems harmless but perhaps could be interpreted in the wrong way?
Well, especially since we're a little bit larger now, so now we have other meeting rooms. But basically, the elected officials go door to door. You know, the only time that they will have a restaurant where they might go to a Rotary Club, they might go to the Elks, or someplace that already has a place that meets all the time. But basically, they go door to door.
So that makes it a lot easier when you're going door to door to avoid impropriety.
Or the Chamber of Commerce. That's basically the only, and they'll do that when they have other, when they all meet and have like a panel discussion.
Right.
Of the clerk of the court, the judge, of justice of the peace, the superior court judge, the recorder, and introduce candidate. And they'll do that at the chamber because it's large enough. But other than that, door to door.
Good point. Well, we're nearing the end of our broadcast here, and I wanted to take time to first of all thank our panelists for being here all the way from Flagstaff, from Yuma, from Pinal County. We're very happy to have you all here. Obviously, experts in the field and people who hopefully can give you some insight into how to deal with these things in your daily life. I want to also thank the folks at the Arizona Supreme Court and the Education Division who put this broadcast on, and believe me, there's an awful lot of work from the folks at Education Services to make this a reality. A lot goes into it, and they deserve our thanks. Mostly we want to thank you. We want to thank you for the interest. I know it's COJET, I know it's ethics, and I know you had to have it, but at the same time, thank you for your attention, for your outstanding questions, your faxes. Public trust and confidence in the courts is really all the courts have to go with. They don't build roads, they don't take out your trash, and maintaining that trust and confidence is not just a matter of ethics, it's a matter of democracy and holding on to what we have in this country. So thank you for your participation, for your time. Have a great week, a great holiday, and we'll see you soon.